Well, hello, my true crime junkies. Listen, we have not really touched a lot on this case. I think I might have posted something a while back, might have been over a year ago, when all this went down with Leilani Simon. If you follow the true crime community, you'll know that this was all over the place. I mean, it was all over YouTube. There were some new developments yesterday on Friday, July the 21st.
Chatham County mother is asking the courts to throw out murder charges in the death of her 20-month-old son.
WTOC has live coverage from the Chatham County Courthouse where the woman charged with killing little one-year-old Quinton Simon says the 19-count indictment she's facing doesn't have enough information to build a defense. Leilani Simon is charged with killing Quinton and then trying to cover it up last year. Quinton's body was found after a massive multi-agency effort that involved digging through a local landfill for weeks.
Our Camille Syed sat in on today's motion hearing where the judge heard arguments on this and two other motions in the case.
Camille, did the judge decide on any of the three today?
Mike, Judge Tammy Stokes did not make any decision on any of the defense's three motions discussed today. Those motions revolved around Leilani's journals, false statements she might have made to police, and the murder charges themselves. Now, you're looking at video of Leilani in court back in March. Today, when she entered the courtroom, she had her hair down, she wore glasses, and was in jail attire with a mask covering her face. Two of the motions discuss concerns Leilani's 19-count indictment. It says Leilani faces more than a dozen counts of making false statements to police, and the defense didn't agree with four of them. The defense argued that she can't be charged with lying about it and if and where she may have thrown Quinton's body away or whether she was under the influence. Prosecutor Tim Dean said Leilani agreed to talk with law enforcement and had a constitutional right to stay silent, but not the right to lie. In a separate motion, the defense claims the counts of felony and malice murder are not detailed enough because prosecutors say they don't know Quinton's cause of death. The defense saying they're worried more information will come out during the trial that defense was not able to prepare for. The defense is asking the state to re-indict Leilani. The prosecution did not agree to that and said the matter could come back in an appeal process. The other motion to stop the prosecution from assessing and using Leilani's journals to build a case took up majority of this hearing. We heard from Leilani's mother, Billy Jo Howell, about how she turned the journals over to police. I'll have that story on B News at 6. Reporting live in Savannah, Camille Syed, WTOC News.
So they're in the grand jury process of this whole trial. So I just wanted to bring up this little article I found because I was like, okay, how long is it going to take, I wonder, before we get to the trial process? And I was Googling a couple of things and I found this article that talks about how the grand jury indictment and everything works. If you're already familiar with this, you don't care to hear this article, I am putting chapters in this video and you can skip ahead, okay? So the grand jury is the last stage in a criminal investigation. And as with all criminal investigations, grand jury proceedings are secret. Grand jurors and trial jurors are selected from the rolls of registered voters in the county and judicial district where they live. Grand jurors are chosen at random from this jury pool. 20 grand jurors are impaneled. That's a lot. A minimum of 15 grand jurors is required to meet and hear the criminal cases. However, only 12 grand jury votes are required to indict a criminal charge. Once impaneled, the circuit judge will appoint a grand jury foreman. Grand jurors and witnesses must take an oath to keep the deliberations secret. And typically, a grand jury panel sits for 6 months. Meeting as often as necessary to consider criminal prosecutions and other matters required by law. So the jury is authorized and empowered by the Constitution and the laws of that state to investigate crimes to decide whether a crime has been committed and whether the defendant can be identified as the perpetrator of that crime. And in order to discharge its investigative duties, the grand jury has broad subpoena powers to compel the attendance and testimony of witnesses and production of documents and evidence. Now, this is interesting. The grand jury's broad investigative powers extend to on site inspection of the county jail, youth detention, and 16th section land. The grand jury can also hear from the circuit clerk, chancery clerk, tax collector, forestry commission, and board of supervisors and make recommendations in their final report. Persons testifying before the grand jury are entitled to immunity from prosecution for the crime being investigated. Of course, every witness has a Fifth Amendment U.S. constitutional right not to incriminate himself, and the grand jury cannot compel a witness to do so. If the target or subject of a grand jury investigation wishes to testify, that person can voluntarily waive state law, grand jury immunity, and U.S. constitutional Fifth Amendment privilege. Anyone testifying before the grand jury is entitled to seek legal advice. However, the subject's lawyer is not permitted to appear before the grand jury and must wait outside. The only persons authorized to appear before the grand jury are the prosecuting attorney presenting the case and any witnesses, such as police investigators or victims. Prosecutors authorized to present matters to the grand jury are the district attorney and assistants, attorney general, and assistants to the county prosecuting attorney. However, when the grand jury votes to indict or to no true bill a case, only the grand jurors themselves are present. Even prosecutors are excluded during the grand jury vote. Unlike federal grand juries, state juries generally do not have a court reporter to record and transcribe witness testimony. Grand juries are authorized to send target letters to subjects being investigated. Anyone receiving a target letter from a federal or state should immediately consult an attorney for representation. So, the indictment. When hearing criminal charges, a jury is authorized to resolve the charge one of three ways. A true bill is a finding of probable cause that the defendant committed the crime. The resulting accusation is called an indictment and identifies the defendant, a concise statement of facts sufficient to notify the defendant of the elements of the crime charged. Jurisdiction of the court, the date of offense, and the signature of the grand jury foreman and district attorney. Depending on the nature of the crime, an exact date may not be required. As long as the defendant is on notice of the charge and its elements, the indictment is sufficient. The grand jury is authorized to indict felony crimes as well as misdemeanors. However, the overwhelming majority of indictments are for felonies only. If misdemeanor charges are indicted, they usually pertain to the felony charges subject of the indictment. So I'm thinking like that's additional charges on top of a, like a big criminal charge, right? That's the way I look at it. No true bill is a dismissal. Okay, a no true bill is a grand jury finding that probable cause does not exist. This means that the investigation is concluded and the charge is dismissed. Finally, the grand jury is also authorized to charge a misdemeanor even if it's not a lesser included offense. In this case, the grand jury sends the charge back to the court it originated from, usually justice court or municipal court. So, by investigating and hearing criminal charges, the grand jury also protects the public from unwarranted prosecution. Even if the grand jury issues a no true bill dismissal, the arrest remains on the record. The arrest and charge can be expunged from government records upon proper application to the court. Okay, so the waiver of indictment and bill of information. The defendant has the right to waive grand jury presentation and indictment after advice of counsel. Frequently, waiver of indictment follows a plea negotiation with the prosecutor, resulting in a more favorable or reduced charge. The defendant can agree to prosecution by a bill of information and a waiver of indictment. Other special considerations for the grand jury are multiple counts and multiple defendants charged in a single indictment. The defendant can file a motion to sever counts and co-defendants in order to provide the jury with a clear and unbiased view of the facts. Severance of counts and co-defendants is granted in order to fairly determine the defendant's guilt or innocence. Amendment as to form only. Upon proper motion by the prosecution, indictments may be amended for form but not substance. Under some circumstances, an indictment can be amended to conform to the proof. See, I feel like that's where we're at right now with this Leilani thing. Habitual offender. Amendments to the indictment that affect sentencing have been held by the state Supreme Court to be formal, a matter of form, and not substantial, a matter of substance. This means that the prosecutor can file a motion in court before plea or trial to charge the defendant as a habitual offender. Habitual offender's status means that the defendant has been convicted of 2 prior felonies and sentenced to a year to serve on each, even if the defendant got probation. An habitual offender can be sentenced to the maximum time to be served day for day without parole or early release. A life habitual offender means the defendant has 2 prior felony convictions, that he served at least a year in prison on each conviction, and one conviction was for a crime of violence. A life habitual sentence means life without parole. Habitual offender sentences, like all sentences, must not be cruel or unusual. The sentencing court has authority to reduce the sentence below the maximum to avoid cruel, unusual, and disproportionate punishment. However, all habitual offender sentences will be served day for day without parole or any early release. So then it goes into like drug enhancement and how it can mess with, well, I guess let's read this. Okay. So, sentencing enhancement for possession or sale of drugs near a church, school, or playground enhances or doubles the penalty for a drug conviction. I did not know that. If the defendant has a prior drug conviction, the penalty can also be enhanced or doubled. The grand jury is authorized to include the sentence enhancements in the indictment. Alternatively, the district attorney, on written motion, can ask the court to amend the indictment to include sentencing enhancements. So, this particular attorney I'm looking at is in Mississippi. Mississippi has a trigger lock law which adds a sentencing enhancement for possession of a firearm during a drug crime. The Mississippi trigger lock law increases the penalty for a drug conviction where the defendant possessed a firearm at the time of the offense or the arrest. Like other sentencing enhancements, the grand jury is authorized to include the enhancement in the indictment. Alternatively, the district attorney can move the court to amend the indictment for the enhanced penalty. I've said this many a time because I don't want anybody to come on my channel thinking that I know all this legal mumbo jumbo and I can give advice. There's plenty of attorneys on YouTube that do this kind of stuff, and I'm not one of them. But if you're trying to understand some of the processes and how it works, I just started watching live trials. Uh, it's been less than 2 years, so I'm still learning from it all. And I was trying to understand how the grand jury part plays in. I mean, I know obviously it's the first step, but I was looking at the Leilani trial and trying to figure out, okay, when is this going to lead us to court? How long is this going to take? So that's just a quick play on that to help anyone who would like to understand. All right, so let's look at this thing for Leilani. She's been indicted on several charges here, and on Friday, the court's hearing covered the motion to squash a subpoena for Leilani's journals. They heard arguments on the defense's motion to drop several charges from the indictment as well. So her mother, Billie Jo Howell, was called to the witness stand today, and she was questioned a bit about the journals that she handed over to the police. I mean, they were part of the search warrant. I don't understand. Everything was done legally. I don't understand why they're making such a big deal about these journals because apparently when she was going through her recovery, which was like, I think about 3 weeks before he was found, well, no, they say that, okay, let me back up. In her testimony, Billie Jo Howell, the mother, testified that Leilani had been in a drug recovery home for 3 weeks before Quinton's disappearance. They suspect his unaliving occurred in October of 2022, okay? My question is, though, is if she was journaling, isn't there no difference in journaling than going on Google and making searches? They pull that up in court all the time. Why can't they use her journals? I don't understand the difference between that and anything having to do with texting on your cell phone. They pull all that into court. I'm confused by that and why that's considered different than any kind of digital information that they could have in this trial. So anyway, There were 7 journals total, and she turned them all over to the courts. She claimed she never knew they existed before the subpoena occurred, and she testified that her daughter told her she uses writing to work through grief. Now, Judge Tammy Stokes heard the arguments on the defense side over the motions to throw out the unaliving charges and some other false reporting charges. They were asking the judge to throw out any kind of false statements charges. They argued that Leilani had a Fifth Amendment right to not to make any statements, and the state argues that she did agree to talk with investigators and was posed natural questions that she did not answer, thus concealing information. They were asking Judge Stokes to squash the murder charges. The defense says the indictment doesn't have any evidence in it. The defense argues that because Quinton was subjected to the violence of the waste management system, no definitive cause of death has yet to be released. The hearing lasted about an hour and 15 minutes, but the judge says she's not going to make any decisions yet. And I was trying to see here, when are they going back to court? Like, when are they going to have another hearing? I don't see anything about that. I guess they haven't set the trial date, so to speak. They're still working out all the details. So I would like to stay on top of this one. I followed this one back when it all went down. I wasn't active on my channel yet when it did go down, but I was following a lot of YouTubers who were discussing the case and everything. So if we get some more information, I'll continue to upload on this case. You guys have a blessed day, and I will talk to you soon.